Okay, this presentation is about the judicial branch of the United States of America. It's kind of long, so I'm going to talk quickly. It also has an interactive component that you need to make sure you write down an answer. It'll be part of your homework that you'll have to bring in. Okay, first, answer these questions. Pause the video to give yourself enough time to answer them. I expect a few sentence answer for each. What impact does the Supreme Court have on you? And what impact should it have? You can pause the video now. Okay, obviously, when we look at the Constitution, it gives us kind of the structure and framework of the federal court system. This I don't expect you to memorize, although it does give you the parameters. For example, one Supreme Court and other courts created by Congress. So the number has expanded number of federal courts has expanded over time as the country has gotten bigger. At least one federal court per state. Right now, there are more than that. In addition, it mentions the judges hold their jobs for life once appointed by the president and confirmed by the Senate, and they will get paid. So they hold their jobs for life and they get paid. Since the Judiciary Act of 1789, the number of courts has expanded, obviously. Today we have 94 districts. Again, at least one per state, and big states have more than one. Puerto Rico has one, other American territories have one, Washington, D.C. has one. That's how you get your number starts to go up. And again, the district court's purpose is for most federal cases, they start in the district level. They have what's referred to as original jurisdiction, which means if it's a federal crime being prosecuted, let's say terrorism or bank robbery or something like that, those crimes are prosecuted in a district court, federal district courts. The one in Northern Virginia that is closest to where we are is in Alexandria. Obviously, state crimes are prosecuted in state courts. We have a double court system in this country, which we'll talk about at another time. In addition, we have appellate courts, or courts where if one feels that his case at the district level the trial was flawed for some reason due to due process violation or some other violation of the Constitution, one can appeal that decision to the appellate court. There are 13, obviously, throughout the whole country. They have zones. Virginia is in the 4th Circuit. This is something that you need to know as well. Here's a map of the different circuits. You'll notice that the 9th Circuit is probably the biggest in terms of both geography and number of people in it, with California being most of that. And the federal circuits, a couple of other points just to make sure we're clear. Yes, Puerto Rico is in the 1st appellate circuit, and Washington, D.C. is the 12th one, which is why you don't see it on the map. It's too small. Article 3, Section 2 of the Constitution mentions basically the jurisdiction of the court, what cases the Supreme Court can deal with. Now, the most important thing we talk about with Supreme Court is this concept of judicial review, which we've discussed in class, and we will talk about again more as the year goes on. It is, as we say here, the power for the court to define what the Constitution actually means. And if a law violates the Constitution based on the supremacy clause in the Constitution, is declared unconstitutional. The courts can declare part of a law unconstitutional, as they did with part of the Bipartisan Campaign Finance Reform Act of 2002, and then they can declare an entire law unconstitutional, which 5 years later they declared the entire law of the Bipartisan Campaign Finance Reform Act of 2002, otherwise known as McCain-Feingold, unconstitutional because of limits on speech and limits on spending money on speech during political activities like campaigns. Marbury versus Madison is the first important Supreme Court case where incoming Chief Justice John Marshall writes the decision for the court saying that Although Madison violated the law, which the law he speaks of is the Judicial Act of 1789, Section 13, the law itself is unconstitutional because it grants powers to the courts that Congress should not be able to grant, and it is the first case of judicial review in our history. Judicial review does also affect other government actions. For example, if the president does something like refuse to hand over tapes, as President Nixon did during the Watergate scandal, that can be declared unconstitutional, as it was in the Supreme Court case U.S. v. Nixon. In the case of Bush v. Gore in 2000, dealing with the presidential election and the problems in Florida with them counting their votes down there, the Supreme Court ruled that in the case where Bush brought an appellate suit against Gore, Gore won a case against Bush in Florida, and then Bush appealed it to the Supreme Court, and the Supreme Court ruled that the Florida Supreme Court had violated its own laws, and it didn't declare them unconstitutional. It just ignored what the actual law said, and therefore that was not allowed to stand, and that's why President Bush won that case. Often members of Congress write laws that are not really specific enough, and unfortunately it falls to the court to define those, which usually means years and years of litigation and confusion before they finally get to an answer. My example here, what does a law banning obscenity mean? We all have probably our own different definitions of what exactly obscene includes. Okay, this is the interactive portion. Effective July 1, all pistols, rifles, and shotguns must be registered, including the serial number and owner name and address. This is a new law that's been passed. No individual can own more than 3 guns. Is this law constitutional? Write 4 sentences on why. I expect you to pause the video at this point and write out an answer, which I will check in class. Okay, at this point you've restarted the video. Hopefully you've written down 4 sentences at least on why you think this law is constitutional or not, including mentioning specific parts of the law as I have created it. Okay, now here's the important part. It's not whether or not you said yes it is unconstitutional or no it's not. It's where did you look for the evidence? How did you justify your decision? Did you go to the Second Amendment? Obviously, judges make decisions by going straight to the Constitution first. If the question can be answered with a quick review of the Constitution, that's where they go. Unfortunately, most of the time, the cases that go to the Supreme Court are much, much, much too complicated to just go to the Constitution and read directly. There has to be some other information that's needed to make that decision. One other area is what we call case law, which is previous Supreme Court decisions. Under the English common law system, which we use in the United States predominantly, court decisions have precedent. Judges like to look at how other courts have ruled on a decision, how other judges have ruled on a decision, and tend to go along with previous decision. That does not mean decision can never be reversed, but it is reluctantly reversed. So this legal concept from the Latin is stare decisis. The idea is let the decision stand, let previous decisions stand. So much of Supreme Court oral argument is based on the attorneys arguing or debating with the judges as to which Supreme Court cases that are precedent are the most important ones for deciding the case. Often the attorney on one side will argue a dozen or 2 cases and the way the court has ruled on those cases as the important ones, and the opposing attorney on the other side will argue a different dozen or 2 dozen cases are the important ones, and then the judges have to decide, the Supreme Court judges have to decide which cases are the important precedents and how they should make that decision. As we move down the list, there are other things that can be looked at. For example, comparison of other state laws. One of the things that was looked at when they were looking at the D.C. versus Heller, which was a gun rights case in Washington, D.C. Mr. Heller wanted to get a handgun, which was illegal in Washington, D.C. at the time, is they looked at other state law. How do other states In this instance, D.C. was considered a state. How do other states handle guns? And it turned out that the D.C. law was the most restrictive in the country by comparison, which certainly led, I think, in part to the court deciding that it should be limited in some way. Okay, then we start working our way down to other topics that are less frequently used, and by many people shouldn't be used, believe that these opinions should not be used as part of the judge's decision-making process. Sometimes it's personal beliefs. Just don't like something. Just think it's bad. It shouldn't be used. It should, guns are bad, as I have listed here. Second, scientific studies. Maybe we'll look at research about whether or not the law is even relevant anymore. Maybe we'll look at laws, whether or not the law is has negative consequences, unintended consequences that need to be looked at. And then finally, which has been done on a few occasions and mentioned in Supreme Court cases, decisions written by the court, what do other countries do? It's actually been mentioned in court cases. How does our law compare to other places? Okay, couple of quick comments on judicial philosophy, and then we'll finish this up. One judicial philosophy, sometimes referred to as strict construction and sometimes referred to as originalist, is the idea that government decisions on power should be made based on only what the Constitution includes and the thinking or the thought processes of the people who wrote the Constitution at the time. So, for example, we look at we look at debate in the Congress at the beginning before each amendment is passed and look at what was said, and that will help us understand what they were thinking when they passed that amendment, for example. So, for example, cases like the 14th and 15th Amendment, which were passed after the Civil War, we can look at what the people who wrote the amendment thought and debated as to the meaning of it. Everything else is just extra. Public opinion, social policy should not have any influence, obviously, in a strict constructionist or originalist approach. Okay, and then the second alternative is the loose or broad construction approach, which is the Constitution should be looked at for guidance, but the Constitution is a living document. The idea that the words were written down 230 years ago and they have the exact same meaning today as 230 years ago seems a bit silly to the loose constructionists. They think the world has changed significantly and therefore the interpretation of constitutional principles should change. In particular, Second Amendment right to bear arms, guns, firearms were very different 230 years ago as they are today. So therefore, the regulation of those firearms should be also correspondingly different. Obviously, in the loose constructionist approach, we still look at the Constitution, but we also look at case law, but we also look at other things like social trends, scientific study, and modern aspects of modern society that may have put the Constitution out of context with what we do today. And sometimes referred to as the Constitution is particularly short, the U.S. Constitution, and that is done or was done on purpose so that we could adapt it to our time and not be stuck following exactly the thought processes of people who lived a very long time ago.